Smarter than you.
All right, well, we're going to start
Yeah.
anyway, because I know you're ready to go. I hate to be the one holding you up. So my name is Marissa, and I'm a trademark lawyer, also running the IP Law Clinic here at the law school. And I want to talk to you a minute about my favorite subject, which is trademarks, because I'm also a fashion attorney, and everyone knows that in a saturated marketplace, trademarks are what can distinguish goods and services. And in fashion, that's exactly, in my opinion, what rules. So we'll start with the ABA rules. So we know that, as my colleague just mentioned, the ABA rules, the USPTO rules now conform to the ABA rules. There's only like one slight difference with the rule that I'm going to talk about, which is competence, which I know none of us have any of these issues, but we're going to talk a little bit about it. This is Rule 1.1, which is the ABA Rule of Professional Responsibility, which also is 11.101, which is the USPTO rule of professional responsibility. And basically it says, I can read the small print, a lawyer shall provide competent representation to a client, and competent representation requires the legal, scientific, and technical knowledge, skill, thoroughness, and preparation reasonably necessary for representation. What's interesting is that on the USPTO rule, they added the term scientific and technical to apply to the patent side. So how do you violate these competency rules? Well, of course, you can take on a matter without having any prior experience. For some reason, patent attorneys seem to think that trademark applications are super easy and that they can just file one sometimes without knowing much about trademarks. You can fail to seek out expert assistance coming to the law school to get an expert student to help you. You can ignore communications from your client, or you can unnecessarily delay the matter. We're going to talk about Yetman. Now, Yetman is not an IP case. This is a probate case, but I thought it was interesting because it shows an example of someone who was in over his head. This is a gentleman who, turns out, he was hired by Claire Bloom, and Claire was an elderly woman. She wanted some help with the administration of the estate of the nephew. The nephew's friend was this attorney, Yetman. And so Yetman comes in, has no probate experience at all, but he says, I can do this. This is not a difficult case. Turned out, of course, it was a difficult case. Here we have heirs that couldn't be found. It's an old will. It's everything that could go wrong went wrong. And so what happened? He basically buried his head in the sand. He didn't respond to her. He didn't respond to the disciplinary board when they asked him, when he came in to be interviewed. He says, oh, I just thought I would be able to do it, but I just couldn't do it. And they wanted him to assign it to another attorney, and he didn't even do that. Now, that's an egregious situation, but sometimes it could come up in trademarks because you think you kind of know what you're doing, and then you sort of get some issues that kind of hit you that are a little different. Now, in the world of IP, though, how do you know what you don't know when you don't know it? This is what happens sometimes when it comes to trademarks, because really on the surface, folks are thinking, I can understand what a trademark is, I know what a slogan is, but maybe you're not so familiar with configuration marks, or maybe you're not so familiar with sound or scent marks. And so those are some of the things, some of the more difficult issues that come up. My favorite go-to place for all the information I need for trademarks is the TMEP. And this is what I tell my students. You've got to at least be able to find it in there. To start, because it is a very dense book. Well, when I was at the PTO, it actually was a book. Now it's all online. The manual, in the foreword it says, the manual is published to provide trademark examining attorneys in the PTO and practitioners, representatives, etc., with a reference work on the practices and procedures relative to the prosecution of applications to register marks. Very simple. What's interesting is that Dahlia George, here's a colleague that I met who's at the Office of Enrollment and Discipline. She says, this is her quote, to be perfectly frank, much of the work product that the USPTO sees in terms of responses to office actions and to a certain extent the initial filings themselves is substandard. This is what she's saying. This is for just getting the application in and just answering like the 7 questions that they're giving you. She says in her experience it's substandard. This is what she said this week. What does she mean by substandard? What are you people failing to do? Failing to consult the ID manual when completing the goods and service description. I mean, this is simple stuff. Submitting an unacceptable specimen if they submit one at all. not providing a translation or transliteration for a foreign mark, failing to submit a disclaimer, or having these arguments that go on and on for 3 or 4 office actions explaining why this descriptive term should not be disclaimed. Or they're failing to provide a complete description or any description of the mark or the design mark. Okay. She says that it's my sense that practitioners view the responsibility of the USPTO examining attorneys as picking up the slack when an application is incomplete and often depending on the USPTO examiner to guide them. So this is what we don't want to do, but this is what she says is happening all the time. And why? Well, let's just say it's because they're pro se. Hopefully that's it. Or maybe it could be, in her words, it was a patent attorney. I know what she has against patent attorneys. That maybe did not quite know what they're doing. But let's talk about some best practices, okay, for some of the things that I have discovered as I'm working through and still practicing, but also some things that I read as I was doing research for this presentation. Searching. Searching is one of those things that you just get better with practice, but it's best not to practice on your client. Where do we go to do our searches? The first step always, that's searching the TES system, the Trademark Examining Search System. You're looking for supplemental marks on the supplemental and the principal register. You're looking for registered and prior pending applications. You're looking for active and inactive marks. Notice that I'm saying you're not just searching the registered marks. You definitely want to search the marks that are not active or that are not even mature to a registration, because those could be common law, protected under common law. You can also hire out a third-party search company, right? And let them do that. Let them do the federal search of the USPTO database. Let them search the World Intellectual Property records. Let them search common law, which would be the state records, internet, the DUNS, market identifiers, business names, etc. Let them do that. But if you're going to do that, make sure that you're designing the search instructions, right? And you're reviewing the search instructions. And here's something that I found was interesting. If you use outside counsel to draft those detailed memos that analyze searches and the results, we almost, oh.
Is this it?
Yes.
Okay. Okay. What did you do? Yeah, no, there's a toggle.
Excuse me.
Most people don't use.
Let me get back over here so we can have some
You can actually have your
images.
laptop and send images from your laptop.
Oh, okay. Okay.
Can you put this full screen for me? Is it full screen? Can you take that stuff off? I'm asking for the moon. Never mind.
Yeah,
We'll
don't
just-
be greedy.
Yeah, there's
Right?
no, there's normally like a little
We can-
double arrow. Where is it?
I have a Mac. Does that help? This right here?
No, that's just
That's
one
not
little.
it? That's gonna maximize it?
Well, but
What are we doing? Somebody,
I think it's if you go up, straight up,
straight up.
go over just a couple more. I think it's the one with the double arrows in the box. No, go to your left. To your left.
Double
Right
arrow.
there. I think-
oh, there it is. That's what I was looking for. Yeah.
Ha! Where all these, are you a patent attorney saying that? Is that a patent attorney?
This is why he runs IT.
Thanks for coming to the rescue. Let's see where I
Because
was.
you created yours on a Mac, is that what it
It
was?
was a PDF.
But you create, your laptop is a Mac?
Yes.
Ah,
I do this every year.
yeah, we don't speak Mac.
I see. Okay, searching. Here we are. Right. So if you're using outside counsel and they draft those great memos, thank you, Latia. Those great memos analyzing your search results, and you happen to rely on that great memo, and that memo shows that there's no infringement when in actuality there might be, you can actually use that memo to evidence that your conduct wasn't willful. So that was something interesting to note. Also, when you're searching, don't forget to search your domain names, because we know that those can also, if they're used as a trademark, can definitely be considered like common law protected. Here's an issue that happens sometime when you name the wrong owner in your application. Because the owner that's listed on the application has to be the person or entity that intends to use the mark or is actually using the mark. If not, then the application is void, okay? So if in this particular instance, in American Forest versus Barbara Sanders, here you have a partnership. The application was, and the registration ultimately was owned by one of the partners, a husband and wife, but it wasn't owned by the partnership wasn't listed. It was just one of the partners. And so that was, they lost their registration for that reason. Another one, if you're a startup and say the entity has not yet been formed, then you're kind of trying to figure out, well, then who should I list as the owner? Well, you want to avoid filing an application in the name of a non-existent entity. So really the question you want to ask to determine if this is a proper owner is who will receive the revenue from the first sale, and that will help you determine that. What to do when you have a related company, knowing that only the company using the mark can own the mark. So if you're dealing with a parent company or the subsidiary company, if they own the mark, then it's fine. But it's a problem, it becomes a problem sometimes when you have a sister company applicant that may not exclusively be using the mark. So one thing that you can do is have that sister company license the mark to the subsidiary and then note that disclose it in the application, and then you can sort of avoid that. Dates of first use. This is one that just trips up folks all the time. Not necessarily the date of first use anywhere, but the date of first use in commerce. Let's talk about it for goods. This would be the dates that the goods were first sold or transported in commerce, provided, of course, at the time of sale that the mark is placed somewhere on the goods, near the goods, associated with the goods. And in other words, the mark must be used on or adjacent to the goods, and the goods must be sold in commerce. Okay. Essie. Big brand in nail polish, all right. Which one, this is like a question, which one of these would be the proper date of first use in commerce based on that rule we just went over? If January 1, the client advertises this Essie polish via a flyer, or January 10, when they actually sell the polish with the brand Essie on it to the customer. What's our first date of use, students? It would be the second one, the date of the sale. So it's because advertising for goods is not helpful. It's the date of sale. Okay, for services, it's a little different. The first date services were rendered under the mark, where you're using the mark in advertisement or display, and the owner is engaged in commerce. So here, we're talking about nail services. The date of first use, would it be the date that your tech launched the website using the mark? Or would it be the date that the first client booked the appointment on the website using the mark? Or would it be the date that the first nail appointment in the salon where the mark was displayed? So the date would be the last one, because that would be the date of where the mark was used in conjunction with the services, and the services were rendered. The services have to be rendered, that's the point. You actually cannot, some folks come and they say, oh yeah, I don't want to file intent to use, and I'm actually doing it, but when you drill down, you find out they don't even have the supplies to create what it is that they need. They don't even have, maybe they're providing legal services. Well, that's not a good one because that's virtual, but let's say they're a nail tech and they don't have any supplies or anything to perform any of these services, so that would be inaccurate. So basically, 1, 2, and 3, 1 plus 1 equals 2. Trademark applications seem very simple sometimes on the face, but in actuality, there can be a lot of hidden issues in those 6 or 7 elements that you need for a trademark application. And if you go back to what Ms. Dahlia was saying over at the Office of Enrollment and Discipline for the PTO, while competence really is an issue, it's hard for them to determine whether competence is really an issue because they can't really always determine who's filing the application. But what seems to be more of an issue for trademark attorneys is communication with the client, making sure that they know when their mark abandons, maybe because you forgot to do something, and what they consider what is diligence. Like following up, making sure that you're prepping them and asking the right questions in the beginning, things like that. Following up with your renewal dates. So thank you very much for your attention.
Well, I knew that Marissa had completed the day because the room was shaking from the applause. Well, believe it or not, right? This is it. This is the end of the day. How many times do you, and I do these programs a lot. In fact, I just did a PLI program with Ian Ballin on Wednesday in New York, right? How many times do you get to the end of the CLE program and you're not